as soon as possible as to which trials are going to proceed and which ones are not, based on what is stacked. So, anything further on this file, Mr. Church?
No, Your
Honor. And is Mr. Albert lodged?
He is in argument.
I'm sorry, what's that?
He's in argument.
Yes. Steve, we're going to need to have the jail get Mr. Albert.
What was it? Albert?
Albert, E-I-L-B-E-R.
All right, he's picking up. Do you want him with Mr. Hibbert or what? No.
No, if they can just put him in the waiting, the
Oh,
video room.
Video.
Yeah. While we're waiting for that, can we proceed on Ms. Harris's case?
We have already received.
Court calls People versus Harris. This is file number 266982. The record should reflect Ms. Harris is present here in the courtroom today. It's the date and time set for sentencing. Yeah, counsel, put your appearances on.
And Your Honor, on behalf of Ms. Harris.
Thank you. Ms. Harris, have you had an adequate opportunity to go through the pre-sentence report and talk to your attorney about that?
Yes, Your Honor.
Okay. Mr. Trush, you've been able to go through that report with your client.
We also received from the prosecutor's office a victim impact statement, and we went over that as well.
For the record, I did get a support letter on behalf of Ms. Harris as well. I had a chance to review that prior to the hearing today. Mr. Trush, are there any additions, deletions, or corrections that need to be made to that report?
No, Your Honor. I do just want to make sure. I think we sent 2 letters before we both of them.
I just got to one. I can't read the can't make out the signature. I was able to read the letter. The letter's legible with the signature. Oh no. Also one from Ms. Bly and Mr. Grant.
Okay.
Okay. Yeah, I did get both of those.
No corrections.
Okay. Are there any challenges to the scoring?
No, Your Honor.
Mr. Rowland, do the people have any additions, deletions, or corrections?
No additions, deletions, corrections. I would advise the court that pursuant to the cases with the Convicts Rights Advocate, the victim is not going to be present for the purpose of sentencing, but she did want the court to take into consideration her statement as contained in the PSI. Okay.
Thank you. Anything on behalf of the people then for allocation?
No, this is a situation where 74-year-old woman was taken advantage of. That's, I guess, the only way I can really state this. It may be that Ms. Harris is good at what she does, and by that I'm not trying to be sarcastic. I mean, in regards to the services she can provide, clean, whatever the circumstances are. However, that does not, I believe, justify the other part of what she does, where she's trying to take advantage of persons who might not know us, being taken advantage of. And I simply ask the court sense to take that into consideration. Thank you, Judge.
Thank you, Mr. Trush.
Thank you, Your Honor. I think that the PSI here does a good job of capturing what's going on here, both in terms of balancing what happened here and Ms. Harris's personal situation, her specific situation. What we have here, I think, and I certainly can understand reading the victim impact statement, how a victim can feel. Certainly there's not a right or wrong answer. Certainly I understand how she feels about being taken advantage of. But I think when we look at Ms. Harris's history here, what we have is someone who's 56 years old and really has not had any substantial interactions with the criminal justice system. I think there's a prior OWI offense a couple of years ago, but really largely has lived her life in the way that we would expect someone to do so. She's not had trouble in the past with the law. In this circumstance, as the PSI indicates, I think she's accepted and acknowledged that there was some motivation from her of desperation from personal circumstances that she was having. I think that she is thoroughly embarrassed and regretful about what happened. She's expressed that to me on numerous occasions. She's expressed it to PSI operator, and I think she's going to express it to Your Honor as well. As we were getting ready for this hearing, I mean, I think frankly, this about sums it up as best as I can to the court. I mean, she told me basically I have to live with the guilt of what I did for the rest of my life. I think that that is indicative of someone who understands what she did was wrong, understands the impact that it had on other people. But I don't think that we should let that have us lose sight of the fact that she has generally lived a life that has complied with the law, been exactly what we would expect, and frankly, has been helpful to other people. The letters here that we provide to the court show a completely different side of her than what I think the court gets. I think the recommendation here to hold jail in abeyance is entirely appropriate. The guidelines range here of 0 to 11 comes with a presumption against jailing. The restitution has been made in this. Actually, I think it's been made sort of twofold over because the bank both returned the money and I think she returned the money as well. Not that that matters, but I mean, it does go to show that she's making every effort to make right on this. And I don't think this is really reflective of who she is. So again, I think that the recommendation here is appropriate.
All right, thank you. Ms. Harris, was there anything you wanted to say?
I just want to apologize to you, Your Honor. Apologize to Ms. Decker several times. I apologize to Mr. Rolla and Ms. Linnell. My attorney just having to pick up time for something that I did. I am truly sorry for what I've done. There's no excuse. There's no good excuse for what I did. It doesn't matter. The issue is what I was dealing with. I'm very sorry.
All right, Ms. Harris, I did read through the report, so I'm familiar with the circumstances that bring you before the court today. There's also a lot of information in there about you and your circumstances personally. And I take all of that information into account along with what the lawyers have had to say and what you've had to say. Again, I did read the letters too that were submitted on your behalf. And I think what the lawyers both had to say is pretty much on point. There's two sides to this. Clearly, you know, at your age, you're in your mid-50s. You really don't have much of a prior record. One recent charge for drinking and driving, but other than that, you know, you don't have anything. So clearly, you're not a person who's engaged in a course of conduct of victimizing people. This appears to me to be a crime of opportunity, and certainly reasonable excuse for having done this is the personal troubles you were having. Certainly doesn't make the conduct okay to take advantage of another person, to change the numbers on a check to be able to get more money. And, you know, I just don't think there's a way that this wasn't going to be found at some point or another. And so to me, that also indicates the kind of desperate circumstances that you were in to do something that ultimately you were certainly going to get caught for sooner or later. The other side of this coin is, of course, the victim in this case. When someone steals from you, that's a very unsettling and fearful experience, traumatizing experience for that person. It makes it hard for them to trust anyone else going forward. And it makes that person leery of having other people help them, and that's detrimental to that person. So there's a price to be paid for that as well. I think balancing those two things, recognizing that this is a nonviolent crime, recognizing, as Mr. Trush has indicated, that we have the statutory presumption now in cases like this against jail time, unless there's some aggravating circumstance. I think the recommendation is completely appropriate. It's going to give you the opportunity to avoid having jail time and to serve a period of probation. But it's also going to allow for the court to hold some jail over your head so that if you don't comply with probation, there will be that penalty there. So The court is going to order that you serve probation for a period of 12 months. The court is going to adopt as the conditions of that probation all the terms and conditions that are listed in this report. The court is going to order that you serve 3 months in the Otsego County Jail with credit for 2 days served. The court will hold that time in advance to be served at the discretion of the court. So again, if you comply with probation and you successfully complete it, you would never have to serve that jail time. If you don't, though, the court can impose that jail time immediately without any hearings, just straight to jail. So I hope that that's a motivating factor for you in complying with your probation. The court is going to order a crime victim's assessment of $130, court cost of $325, attorney fees of $350, the DNA testing fee of $60, $136 state cost, and a $30 per month supervision fee while you're on probation. And Mr. Rolla, just so I'm clear for the record, I don't need to order restitution.
No, Judge, restitutions were made for already prior sentence.
You do have the ability to seek an appeal of this sentence, and that's for both counts to run concurrently. Mr. Trush, have you been able to provide the appellate rights to Ms. Harris?
We went over them yesterday. I'll go over them with her again today. I would indicate to the court, she reports to me that Social Security is her only source of income, so this may be a case where waiving court-appointed attorney fee would be appropriate.
That's something that I'd like, maybe probation. That's something that we can look at as if she's unable to pay that through probation, the court may waive that later on.
Understood.
That's it. Okay.
I guess you should.
Thank you, Your Honor.
All right, good luck to you going forward, Ms. Harris, and just make sure you meet with Ms. Davis before you leave. Okay, Mr. Abbott, if you go to the podium, please. We'll go on the record in People versus Albert. This is file number 266962. The record should reflect Mr. Albert's present here in the courtroom today. If I could have counsel put your appearances on.
We're going back to People.
So you're on behalf of Mr. Albert.
And just so council's aware and everyone else, we've got an issue with our technology here. That's that beeping sound. It's been going on since Monday. They're trying to figure it out, but don't pay any attention to it, and it's not affecting our record at all. So this is the date for the final status conference. We have a trial date set for August 26th. Mr. Trush, have you had a chance to speak with your client about how he wants to proceed?
We have, Your Honor. We'd be proceeding to that trial.
All right. And Mr. Rolla, are the people prepared to go forward?
Yes, Judge. The only question was is whether or not this was going to be the primary on the date or the previous matter again this morning.
All right, so again, since Mr. Albert's lodged, I suspect that this case is going to have priority, but we'll notify counsel as soon as possible on that. Mr. Rolla, are you anticipating any issues that we need to resolve prior to the trial in this case?
None that haven't already been dealt with. Thank you.
I have nothing for the court at this time, although again, I would indicate, generally speaking, as we get closer to trial, prosecutor and I will communicate about those issues.
Okay. And Mr. Trush, have you been able to make any arrangements for Mr. Albert to have appropriate attire and so forth for the trial?
I have not done that yet, but certainly will before the trial dates.
Oh, all right. Mr. Albert, do you have any questions about how we're going to proceed with the case? All right, thank you. That's all. Our next case is Mr. Wadetsky. They're going to bring him up. So let's take a short recess and come back on the record at 9. on the record in People versus Timothy Wadesky. Got a number of files up for hearing for Mr. Wadesky today. We have a probation violation sentencing in file number 256791, and then status conferences in 267011 and 267012. The record should reflect Mr. Wadesky is present here in the courtroom today. Mr. Trush, do you have a preference as to what we proceed on first?
So, Your Honor, in regards to the status conferences, we intend to tender pleas to both of those files today. But we're prepared to proceed on the sentencing as well. From my perspective, I think maybe doing the pleas first would be the best route to go.
Okay. Any objection to that, Mr. Rule?
Not at all, Your Honor.
Okay. So I did receive an affidavit of probable cause as well as a police report. And so I've had a chance to review that prior to the hearing today. Mr. Trush, what is the terms of the plea agreement?
So, Your Honor, in file 267011 FH, we were in receipt of an offer from Mr. Fortier that would dismiss the habitual offender notice. So that would leave him tendering a plea to the attempted assault with intent to do great bodily harm less than murder or by strangulation, that being a 5-year maximum.
Okay.
In file 267012 FH, we are in receipt of an offer that contemplates a plea to 1 count of resisting and obstructing and 1 count of malicious destruction of a building less than 1,000. So that would be a 2-year and a 1 year with a dismissal of the remaining counts in the habitual offender notice. We would seek to be doing a no contest plea as to both. Mr. Wadesky was under medication at the hospital at the time and doesn't have a clear recollection of what happened.
Okay. Mr. Roll, is that a correct statement of the offer?
It is, yeah, correct. Count 1 in file 7011 and count 2 in file 7012, then added count 6 of malicious destruction of the building over 200 but less than 1,000. Contrary to MCL 753.804A, it's a 1-year, $2,000 misdemeanor. Other charges and additional offender enhancements would be dismissed. Right, that's a 5-year. No, it's charged as offender. Okay, yeah, 750.84 bracket A bracket.
Okay. And Mr. Rolla, the people don't have any objection to the no contest plea?
No, Judge, I think the court has, based upon the information that people have in this, I think it's might even be reflected in the affidavit of probable cause that there is a basis for taking that.
Mr. Wadesky, have you had an adequate opportunity to speak to your attorney about this plea agreement?
Yes, Your Honor, he's been very good.
Right. And what we've discussed here today, is that your understanding of what the plea agreement is going to be?
Yes, Your Honor.
Is that how you wanted to proceed today?
Yes, Your Honor.
Can you raise your right hand, please? Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. Mr. Wadesky, you understand that the maximum penalty you could face for the charge of attempted assault with intent to do great bodily harm less than murder or strangulation, that the maximum possible penalty in that file is up to 10 years. Do you understand that?
Yes, I do.
Your Honor, the attempt would be a 5-year.
Oh, I'm sorry. The attempt is a 5-year. Do you understand that?
Yes, we went over that, yes.
Okay. And that the charge of resisting or obstructing a police officer, the maximum possible penalty for that charge is 2 years and or a $2,000 fine. Do you understand that?
Yes, Your Honor.
And that, as we've indicated, the malicious destruction of property charge is a misdemeanor punishable by up to 1 year. Do you understand that?
Yes, Your Honor, I do.
With all of those maximum possible penalties in mind, what is your plea to each of those charges today? Mr. Wadesky, although you're pleading no contest, I need to go through your rights with you. At this point, you do have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial, to not have that silence used against you, and the right to testify at a trial yourself if you wanted. You understand that you have all those rights.
Yes, Your Honor, I do.
Can you tell me what's going to happen to those rights by you pleading no contest?
So if you plead no contest, are you gonna have a trial at all?
I don't know.
So those trial rights are going away.
Yes, I understand.
Okay. So also, if you wanted to appeal the plea that you're making today or try to get this plea reversed, you can't automatically do that, or you don't have a right to do that. You would have to ask for the Court of Appeals to hear your case, and if they said no, then you wouldn't be able to go any further with that. Do you understand that?
Yes, Your Honor.
Okay. Has anyone threatened you with anything to get you to plead no contest?
No, Your Honor.
Has anyone promised you anything other than what we've discussed in court here today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
So again, I reviewed the report prior to the hearing today. I do find that a no contest plea would be appropriate based on, I think, Mr. Wadesky's mental state at the time. It's clear that he was in the throes of a mental health crisis during this incident, also due to the medication that he was administered to help try to deal with that. So the court finds that a no contest plea is appropriate.
Thank you, Your Honor.
I also find that, well, number one, Mr. Trush, have you reviewed the affidavit of probable cause? Thank you. As well as the Gaylord City Police Report number 26421000469?
I did, Your Honor.
Do you find that the information contained within that report would establish a factual basis for finding that Mr. Wadesky is guilty of each of the charges that he's pleading to today?
I do, Your Honor.
Mr. Rowland, have you done
I
the
would
same?
concur, Judge.
I reviewed those reports. The court agrees. The court is going to mark and admit those two as court exhibits 1 and 2. Mr. Rolla, are the people aware of any threats, promises, or inducements other than what's been placed on the record today?
No, Judge.
Mr. Trush, are you?
I'm aware of it.
Mr. Rolla, are the people satisfied that the court has complied with statute, court rule in the taking of this no contest plea?
Yes, sir.
Mr. Trush.
Defense is satisfied, Your Honor.
Thank you. Mr. Wadesky, the court finds that your plea is knowing and voluntary. The court is satisfied based on the information contained within court exhibits 1 and 2 that there is a sufficient factual basis to support a finding that you are guilty of each of the charges that you're pleading to today. The court will accept your no contest plea as to each, and we'll set that matter for sentencing on a separate date. And then Mr. Trush, as to sentencing on the probation violation, did you receive a copy of that violation report?
I did.
Did you have a chance to review that with your client?
We have gone over the recommendations.
Okay. Mr. Wadesky, did you have an adequate opportunity to talk to Mr. Trush about the sentencing on the probation violation?
Sure.
I did. Right. Mr. Trush, I know you have a challenge here to one of the guidelines, I believe, is that correct?
That is correct.
Is there anything about the factual information in the violation report that you're challenging or asking to have changed?
No, Your Honor.
All right, and then,
Or I'm sorry, Your Honor. There was one thing that we did need to correct.
okay,
The jail credit lists him as having 13 days credit. His bond on this matter was set on 5/26 of 26. I think it was, I don't remember what it was set at, but it was a significant cash or surety bond.
50,000.
He's never posted that. By my count, that would be an additional 70 days of credit to today's date.
Mr. Rowland.
Judge, I'm not going to say didn't post it. I would say However, there's a very recent decision that just came out, I think, almost decision 2 or 3 days ago. And as long, and if he gets credit, if in fact he was serving on the matter that he's before the court on, he does not get credit if he was serving that out of the matter. That's been made very clear.
Right.
So
Well,
I guess what I would indicate to the court responsibly to that, there were 3 different bonds that were set. So there's a bond that's set in the probation violation, and then there's a bond that's set in the 2 new matters before the court. Obviously, I haven't seen that particular case, so I mean, I have to review it, but it certainly would seem to me in that circumstance, at a bare minimum, right now, that may sever his credit in the other case, but I mean, he certainly was being held on this.
yeah,
And again, I don't disagree with that, Judge. I just want that clarification for the record.
right. No, understood. I think given still applies to this matter in that he was unable to post bond in this file. He was not under sentence in any other file or serving a sentence during that period of time. So it'd be my view that he would get credit. So he said it's 73 days.
So it's an additional 70, which should make it 83 total.
83. Any other changes, Mr. Chair?
Other than the challenge I filed.
And then if you would address the challenge, then please.
So, Your Honor, we challenged the scoring PRV 2 on this matter, although I do see I inadvertently titled it as a challenge to PRV 1. But the challenge is to PRV 2. It would appear to me that that has been scored for entry 6 of 7. However, that's an attempt at resisting and obstructing. That doesn't qualify as a low severity felony. That would be a misdemeanor as the statute defines it for scoring purposes. Now, in some circumstances, felony is defined a different way. So like for habitual enhancements, that attempt RNO can be used to enhance as like a habitual second felony. But by the definition contained in the scoring guidelines, that would qualify as a misdemeanor, not a felony.
Judge, with all due respect, that's exactly inaccurate as to what the law is, as indicated in people's response to the situation where the attempted felony is treated as an H-class felony, so it's still a low severity felony for scoring purposes, so I don't believe it's going to be scored.
So I had a chance to review the statute as well as the briefs that both parties filed, and I agree with Mr. Rola's interpretation of the statute in this case, and given the nature of this offense under number 6 of 7 as identified by the defendant, I do believe that it would still be scoreable. So the court is going to deny that objection. The guidelines will remain 0 to 17. Did you have any other objections to the guidelines, Mr.
No, Your Honor.
Mr. Rolla, did the people have any additions, deletions, or corrections to the violation report?
No, Judge, thank you.
Anything on behalf of the people for allocation?
Judge, I don't know how I want to say this. I don't know if I can say it any differently. Mr. Wadesky was given a significant advantage in regards to having this matter resolved without significant jail time, but he was unsuccessfully discharged on July 2nd, 2026. Now, I guess there's 2 ways of looking at it. One is, well, look, you could treat it kind of like a probation violation. I actually think someone who's given the benefit to address their substance abuse situations by getting the benefit of drug court or a similar program, and then they feel that I think they actually be sentenced more harshly than if they didn't have that benefit and they committed the same violation, because one of 2 things is the case. Either they had no intention of really going through it in the first place, and they're effectively pulling a con upon the court, or even if they were effectively sincere in the first place, but they didn't complete it, they're taking and using time for somebody else for the benefit of the program who didn't get the chance because they took that spot. Thank you, Judge.
Thank you, Mr. Truth.
Thank you, Your Honor. These are always difficult situations. We want to encourage people to go into treatment and get help. And I think our sobriety court in this county, frankly, just specialty treatment courts in general are tremendous opportunities. Because we take people who oftentimes are otherwise looking at lengthy jail sentences or prison sentences and give them an opportunity to make meaningful change. Obviously, not everybody is going to be successful with that. But I think the question is, do we throw the baby out with the bathwater, so to speak? Mr. Wadesky had some success in the sobriety court program. He was in phase 3 of 4 of the program. Again, was it perfect? No. Did this circumstance that he just tendered the police to cause him to get expelled from the program? Yes. But there were periods of very good success while he was in the program, and he has added tools to his tool belt to address the substance issues that he has. The other piece of this is, and I think Mr. Wadesky frankly kind of hit the nail on the head, right? We use the tools that we have, and sometimes they're imperfect tools. We know that substance abuse and mental health issues are very oftentimes intertwined. I think unfortunately this was a little bit of a square peg in a round hole situation. We don't have a mental health treatment court here in Otsego County, and I recognize we can't have every resource available everywhere. It's just not really feasible, right? I mean, in order for those things to happen, we need judges available, we need prosecutors available, we need attorneys, treatment professionals. It just can't happen everywhere. But frankly, he probably would have benefited more from a mental health treatment court than a sobriety court. With that in mind, I certainly think that a response is necessary as to what happened. I think the recommendation here is generally appropriate. With guidelines of 0 to 17 months, a 12-month sentence is trending towards the top end of the guidelines or higher end of them. Additionally, with that type of guidelines range, there's still a presumption against jailing. Now, again, I'm not going to advocate to the court that the court should be at 0, but I think to say that we should be at 12 is certainly not unreasonable given the circumstances. I do think we also want to be cautious about how much we punish someone for trying and failing. Again, I don't think there's anything to suggest that he didn't put forth an honest effort in the program. It didn't work out, but I do think we still want to encourage people to try to address those needs. Additionally, I would indicate to the court, if the court does follow the recommendation, he does still have work available to him at, he's a manager at Jets Pizza. So if the court would consider a work camp at some point during a sentence, I think that would be appropriate as well. Thank you.
Thank you. Mr. Wadesky, was there anything you wanted to say today?
Yes, sir. I very much tried in sobriety court. I got in a bad car crash when I was 17. I had 41 surgeries, lost my leg. I was in the hospital for 5.5 months. I had 28 Division I offers for football, 37 for baseball. I know how to like put my nose to the grindstone, you know, and I very much did try. What was left out of this whole process was getting mental health help. I did get petitioned multiple times during sobriety court to go to psych institutions, and they did help, but I did just, before I got put in jail this last time, I did go to the last one, and they have me on this regimen of medication that has has helped me. It changed my mind, my attitude, and like how I have been seeing things. And you know, I really wish I could have stayed in drug court. I really wanted to. I feel like, you know, I was in the courtroom and I couldn't say anything. You know, I couldn't advocate for myself, and I wish I could. You know, I've always been a very good worker. These charges I've had have been very unfortunate. I was a store manager of Lowe's in Petoskey. It's a Fortune 500 company. You know, I balance a $50 million P&L, and that's not easy. You know, and dealing with 120 employees is not easy as well. You know, I'm not a useless individual. I really know how to work, and I'm very good at whatever I do. I'm a fast learner, and I really hope that you give me this chance to, you know, to go back to my job and, you know, feel like I'm actually a member of society again, instead of just, you know, waking up for meals and, you know, doing the same Groundhog Day here in jail. It's not who I am.
All right, thank you. I did read through the report, Mr. Wadesky. So I'm familiar with the you know, basis for the probation violation, which is really, I mean, what we took the plea on today, the facts on that. So obviously, as part of that plea, I read through the police report, so I'm familiar with all the underlying circumstances. There's also information in this report about how things went during your drug court program. And I also reviewed the underlying PSI, pre-sentence report from your original sentencing back in January of 2025 on your underlying charges, which also, you know, involved similar type conduct, resisting or obstructing police officers, and assaultive conduct. So, and I take all those things into account, of course, along with what you've had to say. You know, I see people every day. Nobody's all one thing. So certainly the PSI and the police report depict the incidents that you've been involved in, and that's one side. You know, I listen to you. I listen to what Mr. Trush has had to say. That gives me another side, and I can accept it. You know, in a lot of ways, you do things right, and you've had some successes, and that you are, you know, capable of being an asset to society. And unfortunately, you have this other side of you that's very assaultive and very dangerous, and puts yourself and other people in a lot of danger. And part of that is untreated, you know, mental health issues. But even when, as in this underlying incident, people are trying to get you into treatment, it results in violent situations that puts everybody at risk. So I have to balance those two things. And in this case, you know, based on your performance in the sobriety court, based on the violation that brings you before the court here today, and the underlying case, which again involved resisting or obstructing police officers and assault conduct, I do think the recommendation is appropriate. I think there needs to be some jail time to account for your wrongful conduct in this case. And I think the recommendation is adequate to account for your wrongful conduct. 0 to 17, the court could impose a prison sentence on this. I'm not going to do that because of the mitigating factors. The court is going to sentence you to 12 months in the Otsego County Jail. You do have credit for 83 days served. The court is going to discharge you unsuccessfully from your probation. I don't think further probation would be a benefit either to you or to the community. The court is going to preserve the outstanding fines and costs. That is a balance of $1,381 for collection. You do have the ability to seek an appeal of the sentence. Mr. Trush is able to go through Mr. Wadesky's appellate rights.
And Your Honor, just for clarity's sake, would the court consider work can be
That's something that we can discuss on the new cases. So
understood?
you've already remanded to the custody of the county at this time, Mr. President. Trush, had any contact with Mr. Spencer?
He's here.
Mr. Spencer, can you come forward, please? The clerk calls people versus Spencer, file number 266965. The record should reflect Mr. Spencer present here in the courtroom today.
For the record, gentlemen, I call the people.
Hey, Your Honor, Richard Trustry on behalf of Mr. Spencer.
This is the date set for a final status conference and plea cutoff. Mr. Trush, have you had an opportunity to speak with your client about how he wants to proceed?
I have, Your Honor, and I think we do have an agreement that would contemplate count 1 and count 4 as a habitual second and everything else being dismissed. I'm sorry. Is that?
Hey, I'm sure.
The last one.
And I apologize, Your Honor. I have two contradictory things in my notes. One of them,
If the court will allow, it's as to file counts 1 and 4. Count 1 would be the controlled substance delivery methamphetamine, and count 4 is the use of tutor to commit crime, and that's as an habitual second, as Mr. Trudeau.
Okay, so my only question is this, count 1 is the habitual second with the drug double, or?
No, Judge, it's
Okay.
it's not as the drug double, it's as a habitual second.
Okay,
And that's with restitution of $410 to same.
okay. Mr. Trush, is that correct?
again, that is correct.
And Mr. Spencer, have you had an adequate opportunity to speak with Mr. Trush about this plea agreement?
Yes, I'm just a little bit confused about the second.
Sure.
There's a conference room right down the hall.
Oh, do you need to I didn't know if you can just have a quick discussion there at council table?
Sir,
Let's see if it's a question that needs you to leave the room. Mr. Spencer, were you able to get your question answered?
Yes.
Did you want to move forward with that plea agreement today? You raise your right hand, please. Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Mr. Spencer, are you currently on any kind of probation or parole? All right, and you understand that by pleading guilty to count 1, which is delivery of amphetamines as a second habitual, the maximum penalty you could face would be up to 10.5 years. Understand that?
Can I speak with Mr. Trudeau one more time?
Your Honor, he's asking if we could head down the hall to the conference room.
Okay, Mr. Matisse, Mr. Matisse in the hallway there?
Yes, sir.
Can you ask him, Mr. Matisse, can you come in? We can take one of your cases while we're waiting. I'm gonna call People versus Soraya Burns, Saria Burns, 267007. If I could get counsel with your done in that one.
Your Honor, my fellow people.
Gabriel Matisse on behalf of Soraya Burns, Judge. Ms. Burns contacted me this morning. She has her wheel bearing and is out, and her tire is flat, and she asked if she could participate by Zoom. And I said I would ask the court.
So, no.
Understood, Judge. I know.
And primarily, first of all, I want to note for the record, this was set for 9:45. It's now 10:05. Ms. Burns isn't present. I'm in receipt of a report from Ms. Davis indicating that Ms. Burns gave similar excuses, right? Tire problem for not appearing for the PSI interview. Never did complete it. I'm also in receipt of a report from Community Corrections from Ms. Van Wolfen indicating that on July 19th, Ms. Burns tested positive for alcohol twice on that date at 0.06. So she's not here in person at the time for her hearing. It's the court's position that we would issue a bench warrant for her arrest. Mr. Rolla, do you have any different or other input?
Judge, our office provided probation for copies of the PBT violations as well, and for with Ms. Burns's non-appearance at the bench warrant.
Okay, so the court will issue a bench warrant once that's presented by the prosecutor and Mr. Matisse. If you do have contact with Ms. Burns, you should just advise her that she'll need to come in and turn herself in.
I will, Judge. Thank you. And I did speak with Ms. Burns both about the violation and that she needs to be in touch for her PSI. So I've been trying to get her on track with that. So hopefully the bench warrant comes.
All right, thank you. All right. Mr. Matisse, were you ready on Ms. Fennell's case?
Yes, Judge.
Ms. Fennell present. All right, we'll go on the record then in People versus Lynn Marie. Now, this is file number 267003. The record should reflect Ms. Fennell's present here in the courtroom today.
Gabriel Matisse on behalf of Ms. Fennell, who's standing to my right.
Okay. This is the date and time set for sentencing. Ms. Fennell, have you had an adequate opportunity to go through the report with Mr. Matisse and speak to him about that?
I have, Your Honor.
Okay. Mr. Matisse, are there any additions, deletions, or corrections to the body of that?
Ms. Fennell pointed out a couple things she wanted the court to know, Judge. There was an incident that was noted over this 6-year period of sobriety that she's had where she did take kratom. She just wanted to let the court know that she did take 2 pills of kratom one time, but she's actually quite proud of her sobriety over these last 6 years. And she's been in recovery, and she just doesn't like the way this paints it, because at this part of her life, she's pretty stalwart on the fact that she is in recovery. She is maintaining her sobriety, and she feels that the PSI is making it sound like she's struggling with an active addiction. She wanted the court to know that's not the case.
All right, but the information isn't incorrect.
It's not incorrect, Judge. It's just the way it paints it.
All right. Ms. No, you can certainly tell me more about that. You're going to have a chance to say what you want to say today. So I will consider that part of the allocution.
Thank you, Judge.
Are there any other factual inaccuracies?
No corrections, deletions, or edits otherwise, Judge.
All right. Are there any challenges to the scoring of the guidelines?
There are not.
Mr. Rolla, do the people have any additions, deletions, or corrections?
No, Judge, but perhaps, I don't know if it's an addition, but it would address perhaps the issue that was just brought up by defense counsel. Does the court have a copy of the pretrial supervision summary report by Northeast Michigan Community Corrections regarding this, dated August 4th, 2026?
I do.
Okay, I thought you did, and I might think defense counsel had it as well, because in the middle of that report, it indicates, and I'll just read it verbatim, it's this, completed drug screens and Bear River Health as part of the counseling. All the screens came back with negative results. So again, I don't see how that's being in any way, given the perception that perhaps the defense was trying to claim the PSI, that I think as the court's already acknowledged that information was accurate. So With that, Judge, I then have some allocution as presented.
Certainly. Do you have any challenges to the
No
guidelines?
no challenges to the guidelines, no changes as described.
Do you have any victims that want to address the board?
No, you're right.
Oh, then yes, please, allocation.
Thank you. At the time of this offense, the defendant was on probation for driving a license suspended. This is her second felony. She had 3 prior juvenile theft offenses. This is the second adult one. This is a circumstance where restitution in the amount was $1,095.75 to the Walmart. Again, as I know this court said it, I know I've heard it from Judge Hunter on numerous occasions. A lot of people think it's just retail fraud, it's no big deal, but unfortunately, I have to agree that in a community, especially like ours, where it's not a supported society, where theft is done from retail businesses, it costs everybody because then the prices have to go up. So it's not just a little thing that, oh, well, you know, it's a big company, they can afford to absorb this. No, they pass the cost on to their customers. So although retail fraud thefts are often treated as if it's not that much of a big deal, again, it has an effect on the entire community. And under the circumstances, I think the recommendation is appropriate. Thank you, Judge.
Thank you, Your Honor. Ms. Fennell's been through some things recently. One of them was a change in her income, and that was something that she adjusted to poorly. And I just had a conversation with Corsica about this and said, what is the driving factor here? So the best way I can describe this to the court is there was something missing in her life, and she had a loss recently. There was an income change. And when she described it to me, she said, you know, when I really think about it, it was greedy. It was greedy. What I did was greedy. I was taking things I shouldn't have taken. Some of them I did need for my kids or somebody at the time. Other things I was just taking. It was greedy, and the way I was looking at it was wrong. Just absolutely wrong. I'm not entitled to those things. The prosecutor's right. That's what that does. That's exactly what that does to everybody. That brings up the price. It makes people have a worse shopping experience everywhere. It makes things more difficult for everyone, and it's not a victimless crime. This community, as far as I know, and I'm new to it, is a very giving and considerate community when people are in trouble, as far as I understand. And I've encouraged Corsica to realize that she needs to reach out to family and community supports when she has issues, whether they're depression or traumatic or simply some urge to take something that's not hers. And she wants to tell you about this, but given what she's been through, Judge, we'd ask for the lowest end of the sentencing guidelines at all possible. She knows that what this is doing is taking her away from her family, her children, and she wants to be there for them. And she knows that this is her choices that have gotten her here. She understands that's why she's here. She just wants to do the right thing. So if the court wants to sentence her to a period of incarceration, I'd ask that the court consider any kind of potential community service or work camp so she can give back to the community in some meaningful way as part of the rehabilitation and punishment aspect of this crime. Thank you, Judge.
All right, thank you. Ms. Fennell, is there anything you wanted to say today?
Yes, I would, Your Honor. I would like to real quick go back to what the prosecutor said. This isn't a victimless crime. Yeah, it's retail fraud, but it affects more than just Walmart. At the time, obviously, I wasn't thinking of it, but I do know. I am fully prepared to pay back everything that I owe Walmart. I'd like you guys to know that a lot of things have changed since this PSI. I am now, my mother moved home with me and my 3 kids. And so it's just, I'm no longer in the relationship that I was in. It's just me and the 3 boys at home, my son. It's a big year for us. My oldest goes into intermediate to new school. My youngest starts school. He's my last baby. You know, I've done a lot to change my life, but obviously I'm still doing some things wrong. I do have new support. I am in a new program through DHS that they have approved me for cash assistance and other things that have given me the tools that I don't need for anything. They also have given me 3 months to get myself together before I have to get a job. I did get a job offer back at River House, which is the domestic violence shelter that I was employed at. With this new charge, I do not know if that'll make a difference, but I do have a job offering. I am in grief counseling, I am in domestic violence counseling, I'm in addiction counseling. I go to Bear River every 2 weeks. I'm on Spoxton. I have checked in with my bond agent. I have answered every community corrections message, every text or call from Gabriel. I just asked it, I do believe that a felony retail fraud, deserves some incarceration time, and I just asked the court that instead of putting me in jail, you allow me to possibly do work camp where I can give the community my days, and I'm still home at night with my children. And I believe that's all I have to say, other than I'm really sorry for what I had done to Walmart, and I'm sorry for.
All right, so I did read through the report. I'm familiar with the circumstances of the crime here, as well as your background. And so I understand some of the things you're saying in terms of what's gone on with you. Obviously, I read through the community corrections report with, the exception that you didn't obtain employment. It looks like you did comply with all the other conditions. And testing negative is important, especially while you're on bond. So there are certainly some positives here. I think, the negative is obviously your actions in this case. And looks like there was a fair gap with the exception of the suspended license issues. Fair gap in criminal conduct. But certainly your actions in this case unjustified, no reason to do what you did. I completely agree with Mr. Mertz. There are a lot of community resources, and most of the time people just, whether it's laziness or they just don't want to seek it out, they don't look for those resources, but there are people out there that would help. It really took the time to look for that. Unfortunately, people tend to take the easier way out because that's it's trouble. In terms of how to address it, I went back and forth on your case. I read through the PSI a number of different times because you are kind of on a precipice, I think, in terms of your prior record. Been on probation 5 times, been at 5 prior jail sentences, and those numbers on their own in a vacuum start to tell me as a judge that those other lesser punishments haven't worked and that it's time to do something different. And so they're certainly looking through this. I consider the possibility of prison because your guidelines are 7 to 23. So the court would be completely within the guidelines to sentence you to a prison term. But, there are some mitigating factors here, and it does appear to me that you're making sincere efforts to address some of your underlying problems. And so I do think, all things considered, while in other cases, I certainly may impose a prison sentence, I think in your case, looking at this individually, I think it's appropriate to give you an opportunity again for probation and some jail time. I am going to order that you serve some jail time up front, but I'm going to have a substantial portion of that allowed your work camp. And then it's going to be up to you, to see how you do. And if you don't do well in work camp, then you'll have to serve the time in the jail. If you violate your probation, right now your guidelines are up to 23 months. And if you come back on a violation, there's not going to be much reason for me at that time not to impose a prison sentence. So a lot of this burden is going to be on you going forward as to how things go with your life and whether you stay out of prison or whether you go to prison. And so I'm going to give you that opportunity, but the burden's going to be on you. The court is going to sentence you to probation for a period of 24 months. I am going to adopt as the conditions of that probation all the terms and conditions that are listed in the report. That includes payment of restitution in the amount of $1,095.75 to the Otsego County Clerk to be dispersed to Walmart. The court is going to order that you serve 12 months in the Otsego County Jail with credit for 3 days served. The court's going to order the first 3 months of that to be served in the jail. The court has no objection to release to work camp after the first 3 months. The court is going to order $130 crime victims assessment, work court costs of $325, attorney fees of $350, $68 state costs, supervision fee while you're on probation of $30 per month. You have the ability to seek an appeal of the sentence. Mr. Matisse, can we go through the appellate rights for this? No.
Judge, my client would like to know if it's possible she could report maybe on Friday.
I just don't have my son enrolled. I tried to go on the 3rd to Otsego to North Ohio, and I didn't have his birth certificate. I did receive it in the mail. I didn't have it. I don't have another person who can enroll me in school. I will not run. I am not a flight risk. I didn't realize this guidelines till today. Okay.
Sorry.
Thank you, Judge.
Mr. Matisse, did you go through the appellate rights with Ms. Bennett? Have her acknowledge receipt of them, is all you really need to do. And Ms. Vanilla, you're going to go with the officers at this time, please. Thank you. And Mr. Matisse, I'm going to take a case that we passed. So, Mr. Truish, if you and Mr. Spencer could come forward, please.
Thank you, Your Honor.
Deputy, you can bring Ms. Malcolm up. Okay, we're back on the record in People versus Spencer. Mr. Truish, how did we want to proceed today?
Thank you, Your Honor. We appreciate the time to talk. Mr. Spencer at the last hearing indicates to me that he thought he understood or heard the offer to be pleaded count 1 and 4 without enhancement. I did go over with him, what the enhancement, what all that would mean. Functionally, it doesn't change what we discussed as guidelines and things like that. And I think he is prepared to proceed forward with the offer as it is today.
Okay, Mr. Spence, did you have enough time to speak with your attorney? Yes. Okay, did you want to go forward today? So again, you understand that the maximum possible penalty for each of the charges that you're pleading to would be up to 10.5 years. Yes. With that in mind, what is your plea to each of those charges today? Right now, you have certain rights. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond a reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial, to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights. You understand that you're going to be giving up and waiving those rights by pleading guilty. Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you can only do that by leave, and that means you have to ask for the Court of Appeals to hear your case. If they said no, that's the end of any appeal. Do you understand that? Has anyone threatened you with anything to get you to plead guilty? Has anyone promised you anything other than what we said here in court today? Is it your own free choice to enter this plea? Are you pleading guilty to each of these charges because you are actually guilty? The information I have indicates that these matters occurred sometime between January of 2025 and March of 2025. Is that the correct time frame? Yes. During that period of time, were you present here in Otsego County? Did you, at some point during that time while you were in Otsego County, give or sell some amphetamine to another person? Okay. Did you have any legal right to do that? And Mr. Trush, I'm not sure how the computer charge comes in here. Maybe if you can flesh that out.
When that sale of amphetamine happened, did you use your cell phone to coordinate that?
I had a phone call that was called to the SOD.
And that was a smartphone that was used to coordinate that?
Thank you. Mr. Roller, are you satisfied with the factual basis?
Thank you, Judge.
Mr. Church.
Defense is satisfied.
Counsel, are either of you aware of any threats, promises, or inducements other than what's been placed on the record?
My people, thank you.
No, you're right.
Are you both satisfied the court has complied with statute and court rule in the taking of this plea?
Satisfied, thank you.
Defense is satisfied.
Thank you, Mr. Spencer. The court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there's a factual basis to support a finding that you are guilty of each of these charges. The court will accept your guilty plea. We'll set this matter for a sentencing hearing at a later date. You'll be notified of the date and time of that hearing as well, Mr. Trush. It's important that you stay in touch with him between now and then. Before you leave today, you're going to meet with Ms. Davis from probation to set up a time for a pre-sentence report. Do you have any questions? Now, the court will also adjourn the trial date in light of the plea here today. And that's all. Mr. Matisse, we're having this mountain brought up. And so I'm going to take a short break. We'll come back on the record in about 5 minutes. Okay, thanks, John. We're on the record in People versus Crystal Marie Mountain, file number 267001. If I could have counsel for your appearances on it.
Your Honor, record on behalf of people.
Gabriel Matisse, on behalf of Crystal Mountain, who is here at my left.
Thank you. This is the date and time set for a sentencing hearing in this matter. And Ms. Mountain, have you had an opportunity to go through the pre-sentence report and talk to Mr. Matisse about that? Okay. Mr. Matisse, are there any additions, deletions, or corrections to that report?
Judge, I saw in there that she does not take psychotropic, or has never, I believe was the language, taken psychotropic medications. She, yeah, it says, yeah, she's never been prescribed any psychotropic medications. I believe she's prescribed a couple psychotropic medications, Judge. She's been prescribed Seroquel, as well as Klonopin and Trazodone altogether. So I believe Seroquel falls under a psychotropic medication, but otherwise there's no corrections, deletions, or edits. That's on page 21.
Okay. Just looking for that particular sentence.
It's 3 sentences in under mental health narrative at the bottom.
Oh, I see. Okay. If we added other than Seroquel,
That's right. Klonopin, Seroquel.
okay. Other than Klonopin and Seroquel. Okay. Okay. Is that language okay though?
Yes.
Okay. Thanks a
No
lot.
action, Judge.
Okay, so we'll have that added in there. Any other corrections?
No other corrections, deletions, or edits, Judge.
Any challenges to the scoring?
No, Judge.
All right, thank you. Mr. Rolla, do the people have any additions, deletions, or corrections?
No additions, deletions, or corrections. I recognize the person is still waiting to receive the restitution information, so we ask that be just preserved.
Okay,
Also, Judge, I'm so sorry.
Sure.
Ms. Mountain's pointing out something about her incarceration in prison.
okay,
She mentioned to me that in here, it says she's been in prison 3 times. I believe what it says. The record indicates 6 prison terms. It might be 6 terms of imprisonment, but not 6 terms in prison. I think some of these might be jail sanctions that they're referring to.
so you're saying there may have been some concurrent sentences,
I believe so. She's telling me that she has not been in prison 6 times.
6 separate times? Okay. Ms. Davis, I don't know.
Okay, this is her previous consent report.
And Judge, they may have worked concurrently, so they would be 6 terms.
Yeah,
But
that's
you may have several terms on concurrent.
it. Just so we can clean up that.
Yeah, okay.
That's what she's concerned about. Thank you.
Yeah, so I mean, I can certainly take into account the fact that while you've had 6 cases involving prison sentences, that you actually only went to prison 3 times. Oh, you had 6 sentences all in one case, or you served all 6 at the same time?
I never had 6 sentences at once, Your Honor. I only had 1 sentence and I went once to prison.
Okay. All right. Okay, I will take that into account, recognizing that as far as I'm concerned, the conviction and sentence part of it is correct. Okay, Mr. Rolla, did you have any challenges to the guidelines?
The challenge to the guidelines or additions to the guidelines.
Do you have any victims that wish to address the court?
Not present, thank you, Judge.
Thank you. Anything on behalf of the people for allocution?
Very briefly, this is a 55-year-old defendant who was in Bear River, hopefully getting help for what she clearly has some substance abuse issues. For reasons which are maybe only known to Ms. Mountain herself, she chose to, instead of taking advantage of that situation, reported to other individuals there that she was going to escape, that she was going to steal the vehicle. She was, in fact, that when one of the employees was actually delivering meals, took advantage of the vehicle being running, jumped in the vehicle and fled, and didn't just flee and put herself in danger, but as the PSI indicates, and as the police reports indicated, she led on a multi-county chase where stop sticks had to be used to stop her vehicle after exceeding speeds of over 100 miles per hour. Passing numerous vehicles on various roads, whether it's 27 or trying to go to the freeway, regardless, other people were fortunate enough to get out of the way. This Mountain is lucky she's not here on a vehicular manslaughter case or something to that effect. These are her 8th and 9th felonies, and the guidelines in this case are 12 to 30 months, up to 75 years. Up to 7 years, I'm sorry. This is a situation where a MDOC sentence is warranted, period. And as to the restitution, again, we ask for the review.
Thank you, Mr. Matisse.
Thank you, Your Honor. Ms. Mountain has had, and as you can see in the PSI, she's had lifelong struggles with mental health and wellness. She told me that while she was at Bear River, she got paranoid, and this happens to her. She gets very paranoid that people are after her, and she got paranoid that the other people at Bear River were after her at some level. She just panicked and took the car, is what she's telling me, that and when I asked her why didn't you stop, she said someone was chasing me. I didn't want to stop. It almost seems like she just had some extreme tunnel vision and just kept on going. That was very dangerous. And she understands that. She understands she was at a place of help. And her explanation is simply that she gets paranoid and panics and doesn't know what to do. And that's why she didn't stop the vehicle. She just knew someone was chasing her, and I don't know how she was sorting it out. So she'll let you know. She'll tell you, but that's what I have on this situation. So while this is dangerous and it is sad, and sentenced as the court fashions, the court to keep an eye towards the fact that she does have mental health issues. She has trouble sorting things out, and that's not an excuse. It's just a fact of who we judge. Thank you.
Thank you, Ms. Mountain. Is there anything you wanted to say today?
Yeah, I would like to apologize because I did go to Bear River, volunteer. I went on my own. As soon as I got out of jail, I ran right to Bear River. I did get paranoid, and I didn't tell people I was going to steal a car, Your Honor. I told people I was scared. I was asking for help. And everybody was like, well, there's no way out of here or something like that. You know, it just fed into my paranoia. And I just seen that car and I just took it, and I thought it saved my life. And that's the truth.
Well, Ms. Mountain, I did read through your report, so I'm familiar with what happened in this case. And then I'm also familiar with you and your circumstances, your background and your past struggles as well. And so I take all those things into account, along with what you've had to say and with what the lawyers have had to say. And, you know, I absolutely think, based on your record, as well as what happened in this situation, that you do have some untreated mental health issues that need attention and that cause you to do things that somebody who's more regulated probably wouldn't do. And this situation just completely looks like that to me. This is not something that somebody who's thinking properly would do. And I'm convinced, based on, you know, your past history and prior attempts at community supervision, that that's not adequate to deal with the problems that you have. This was a very dangerous situation, and if you had, as Mr. Roll indicated, I think you are lucky, and the rest of the people that you encountered on the road that day are lucky that this didn't turn out worse. And for somebody innocently driving down the road, if they're hurt or killed by your actions, to them and their family, it doesn't matter what's happening with you. They just know that something bad has happened to them. And so I've got an obligation to look out for those people and to make sure that you're not in a position where you get yourself into a spot where you're acting out like this. So I hope that through the state, you could get some more help than what you could get here locally for your underlying problems. I think it's important, again, for the protection of the community and safety of the community, that you be in a place where you don't have access to vehicles to be able to do this if you do have a mental health crisis. So I do find that primarily for purposes of protection of the community, that a prison sentence is warranted. Again, there have been many attempts through probation, 13 times on probation, 19 prior jail sentences at community corrections that just haven't been successful. So the court is going to follow the recommendation and sentence you to the Department of Corrections, Michigan Department of Corrections, as to the unlawful driving away charge, to a sentence of 30 months to 7.5 years with credit for 102 days served. As to the fleeing and eluding, 28 months to 24 months to 3 years. Again, with 102 days served, those sentences to be served concurrent to each other. The court is going to preserve restitution, crime victims assessment of $130, court costs of $325, attorney fees of $350, and $136 state costs. You do have the ability to seek an appeal of this sentence, and Mr. Batiste, if you could just have Ms. Mountain acknowledge receipt of her appellate rights, please. Ms. Gardner handed to the custody of the state this time. People versus Sean Cox, file number 256932.
Representative from the people.
James Dick on behalf of the.
Thank you. Yes.
This matter, at our last hearing, it was a sentencing hearing. Mr. Cox, the court granted Mr. Cox a 90-day delay to make payments at $100 per month. At present, Mr. Cox has made $300 in payments since that delay. However, he did just submit them today because he does not have a bank account or a means to get here. But he did make the payment today. Just to give the court an update on the status of the case.
Judge, I need confirmation in my office earlier this morning, sometime before 10 o'clock, a $300 payment was made.
I didn't get anything in preparation for this hearing today, so I don't recall where we were at 3 months ago. So, Mr. Dick, how did we get here?
Your Honor, so this was a matter where Mr. Cox originally had pled guilty to fail to return rental property, 200 to 1,000.
Oh, okay. This is that rental car, and he was lodged in
Yes.
Okay.
And he admitted here to the court that he did neglect to follow up with the person who he had entrusted to return the vehicle. The person never returned the vehicle, and he was not able to. Well, he didn't know that the vehicle was not returned while he was incarcerated. Following that, Your Honor, Mr. Cox was arrested on the failed to return property. ultimately entered a plea here with the court. At the sentencing hearing, Your Honor, Mr. Cox made a $1,450 payment for before that hearing, or just before that hearing, and I did request that the court perhaps extend a delay for him to complete paying the restitution. This matter, it was $2,693. Pardon me.
$2,652.98.
Okay.
And the remaining balance is $882.91 at present, Your Honor. The court did grant that 90-day delay and did require that he make a $300 or a $100 per month payment just based on his minimal income and the fact that he had also sold his vehicle to reach that $1,450 amount that he paid initially. Mr. Cox is still living in a rather remote area. He was able to borrow a vehicle to come here today. However, he's not been able to move into town yet because of income reasons. And with that being said, Your Honor, I believe, although he didn't make each month $100 in payments, he did make a $300 payment today. He is showing good faith to the court that he is intending to continue doing what he is required to do. And we would ask at this time if the court might consider just a conditional sentence at the end of this delay now, where he would be able to make the $100 month payments through the next 9 months to satisfy the restitution in full. And I ask the court for the conditional sentence versus traditional probation solely to avoid the additional fees based on his income.
So was the plea agreement conditioned on the payment of restitution prior to sentencing? Is that why?
Yes, it was, Your Honor. And with every possible means, he, prior to sentencing, he was only able to come up with the $1,450, including taking, I believe, a discounted sale on his car because he needed the money right away.
Do you happen to have a copy of the original PSI? Okay. Mr. Rolla, do the people have any position on how the court should proceed today?
Well, Judge, I've just provided some additional conditions. It is correct, his client made a payment of $1,000 on May 6th, 2026, and then today made an additional payment of $300. However, that also, although that goes to his credit, as the court may recall, and this is reflected in my file notes as I entered them at the time it occurred, back on February 4th, 2026, when the defendant showed up after not showing up for the previous one, he provided a factual basis, but he also advised the court that he was on a deferral to a similar charge out of Mount Mertz County. I don't know what the result of those are at this point in time, but you have to get to the point in time where we have to put an end to this, and this can't be repeated. So I leave that to the court's discussion.
Okay. So Mr. Dick, I guess what my decision would be in terms of going forward today would be to sentence Mr. Cox today. I do find that he's making good faith efforts to pay on the restitution, so I would not impose any jail time as part of the sentence today. And then I would set this for a review hearing in 9 months. At that time, if the restitution's been paid off in full, then the court would not impose any additional penalties. If it hasn't, then the court would consider jail time at that time. So I'm not going to be placing Mr. Cox on probation and this isn't going to be a delay of sentence because I'm going to impose sentence today. I'm just going to hold jail time in advance pending a determination on payment of restitution. So all of that being said, that's how I'd like to proceed today. In terms of the misdemeanor report that was prepared, I don't know, did we address whether there were any inaccuracies, any changes that need to be made at the last hearing?
We did, Your Honor. There were.
Okay. And did the parties have a chance for allocution at that time?
That was why the delay was extended.
Okay. All right. So then in terms of imposing sentence today, Mr. Cox, what the court is going to do is, number one, I'm going to impose the full amount of restitution, less what you've paid. The full amount of restitution was $2,632.91. The court is also going to impose a crime victims assessment of $75, court costs of $325, attorney fees of $350, and a $50 state cost. Court is going to order that Mr. Cox serve 2 days in the Otsego County Jail with credit for 2 days served, additional jail time to be held in advance. The court will set this for a restitution review hearing in 9 months. And at that time, the court is going to require Mr. Cox that the restitution be paid in full. And he'll be required to appear at that hearing so the court can confirm whether or not it's been paid in full. And you'll have an opportunity to consult with your attorney prior to that, of course, as well. You do have the ability to seek an appeal of the sentence because this is a misdemeanor. There are no written appellate rights. However, if you did want to seek an appeal, you would need to do that within the next 21 days. If you have further questions about that, ask your attorney, Mr. Dick, will be able to explain that process to you. Mr. Rolla, is there anything further we need to address for the record today?
No, Judge, thank you.
Mr. Cox, do you have any questions about how we're going to proceed? Thank you. That's all.
Judge, I do have a question as far as how much restitution he still is owing, because I actually have to put that in the computer.
Oh, okay. Mr. Rolla, or Mr. Dick, do we have a current balance after the payment today?
That's the court meeting, Judge.
Oh.
Looks like where the original total was $2,630.91. He made a $1,400 payment and an additional $300 payment. That would reduce his net outstanding balance to $932.31 unless I'm accurate.
I calculated 82.
Not 1750, 1700.
314. Yep. So, yep, my apologies.
$932.91, Judge.
Okay.
Okay, thank you.
Okay, thank you. That's all for today. Court calls People versus Adam Fletcher, file number 267015.
Record John, my call down to People.
James Dick on behalf of Mr. Fletcher, standing to my right.
Thank you. Mr. Dick, can you tell me the status of this file today?
Yes, Your Honor. So we are very near resolution. However, Mr. Fletcher does have another case that arose right at the same time as this one, and it is out of Crawford County in front of yourself tomorrow. We are seeking to reach a global resolution that would ask for a brief adjournment. Hopefully, the prosecutor.
Let me address something to do so. Our office, to my knowledge, I didn't see any notes that have been contacted by Crawford, so that's new information.
Okay. Are you representing Mr. Fletcher and Crawford as well?
No, Your Honor, Mr. Truish is.
Okay. All right. My concern is that tomorrow in Crawford, Mr. Trush is gonna say we need an adjournment because we're trying to talk to Otsego. So,
Well, it's my understanding that it's being worked out with Ms. Cope in Crawford County as far as the resolution.
okay. All right. Okay. Then the court will set this for a plea hearing status conference in 30 days. Mr. Fletcher, do you have any questions about how we're going to proceed with your case here? Thank you. That's all for today.
Thank you, Your Honor.
People versus Timothy Farner, file number 266992 and 6993.
For the record, I told the files around my phone there.
James Dick on behalf of Mr. Farner, Your Honor.
Okay. This is the date and time set for a sentencing hearing in this matter. The record should reflect Mr. Farner is present here in the courtroom today. Mr. Farner, did you have an adequate opportunity to go through the pre-sentence report and talk to your attorney about that? Okay. And Mr. Dick, I know that you do have, I saw your sentencing memorandum. I had a chance to review that. And it looks like, well, I guess I would just ask that you go through the factual corrections.
Yes, Your Honor. I don't really have any challenges to the contents of
Okay. It's mainly the issue of the major controlled substance offense factors. Okay. What would you like to say in terms of oral argument on that today?
Your Honor, I think the court understands most of what I've presented. The methamphetamine is not the major controlled substance offense that would be precluded by under the delay statute. There's a specific carve out by the legislature for methamphetamine specifically. It is relevant, however, of course, to the actually, forgive me, Your Honor. You just wanted the argument to that.
Well, I guess my question is, if the court is, that only is relevant if the court is going to oppose a delay of sentence.
Yes.
Okay. All right. So I don't need further argument.
Very
good. Do you have any challenges to this morning of the guidelines?
Unfortunately, Your Honor, I do not.
Mr. Rolla, do the people have any additions, deletions, or corrections?
Additions, deletions to the body report, the challenges to scoring needed.
Thank you. Anything on behalf of the people for allocation?
Judge, I'll have to tell the court about the dangers of possession of meth, much less delivery of methamphetamine that are affecting our communities. These are the defendant's first felony, but unfortunately, he has two prior also controlled substances. So obviously, I think we need to address that issue. Thank you.
Mr. Dick, anything on behalf of your client today?
Yes, Your Honor. I would note that while Mr. Farner does have prior controlled substance offenses, they were marijuana versus methamphetamine, where marijuana is something that the legislature saw fit to decriminalize. However, it does not negate the fact that it's still a controlled substance. As it pertains to Mr. Farner, Your Honor, he does have some misdemeanor offenses. He does not have prior felonies. This particular matter is something when he was stopped by police in both files, Your Honor, he was cooperative, and he he took responsibility for what happened. Mr. Farner, he does, and as it's noted in the PSI, he did have a brother who he lost to substance use in 2021. However, the nature of substances, methamphetamine, undiagnosed perhaps mental health issues are such that people generally or very often find themselves utilizing substances to deal with underlying issues. And rather than seeking out counseling, which Mr. Farmer did acknowledge since he's been sober since this incident, he acknowledged that counseling would be beneficial too. That being said, Your Honor, as Mr. Farner provided and is noted in PSI, he was using approximately a gram of methamphetamine daily up to the date of this incident. My apologies. All right. Well, he was using methamphetamine. Since the arrest, he has not used anything. He's not allowed himself to even stumble as it comes to substance use. He understood the consequences of his actions. He has been working diligently to save money as he anticipates a prison or anticipated a prison sentence. So he's been saving money for his child, his mother. And with that being said, Your Honor, we, of course, if the court would consider a departure from the guidelines, it is noted in the sentencing memorandum where the court would be permitted to do so. The sentencing guidelines do not require a substantial compelling reason. It's merely the court to provide a reason for a departure from the guidelines, as was amended in the legislature in 2020, where it had officially updated the text of MCL 769.34, which became effective March of 21, which erased the substantial compelling language. With that being noted, Your Honor, we would ask the court to consider that departure and sentence Mr. Farner to some sort of treatment-based sentence versus a prison sentence. However, if the court is still inclined to impose prison, we would ask that the court sentences him at the bottom end of the guidelines and perhaps refrain from any objection should he be screened eligible for yes, yeah.
Thank you. Mr. Farner, is there anything you wanted to say?
Yes, sir. The last year and a half, I've had a lot of time to reflect on everything that happened. And I've never tried to blame it on anyone else. I've never denied that I was doing something wrong. Felt kind of hit home this morning when I was telling my daughter I might not see her for a while, telling her mom I might not see her for a while, telling my mother, my sister, might not see them for a while. And just want the court to know that the gravity of the situation is not lost on me. And I have no one to blame but myself. I generally have felt remorse and extreme guilt for the last year and a half since this happened. Kind of at a loss for words right now. All I can ask is for some understanding and leniency in the situation.
I haven't touched any drugs since I was picked up. And, the pretrial, Jessica from pretrial services, I think said I haven't, sorry, I haven't filled any drug tests. And I've been complying. Than that, just like to apologize to my family and to the court for my bad behavior in the past. That's all I have to say.
Mr. Farner, I did read through the report, so I'm familiar with the circumstances that bring you here today. There's also a lot of information in that report about you and your background and so forth. And I've read through all of that as well, along with the report from Ms. Van Wolfen through Community Corrections. We take all of that into account along with what you've had to say and what the lawyers had to say. And number one, certainly it's one thing to have a substance use disorder and using substances. It's another thing to be engaged in providing those to other people. And that's why the legislature provides for harsher penalties, because that's something we want to discourage even among people who are using. And I certainly understand the process of selling some in order to support your own habit. But the fact is, as dangerous it is for you to be using when you engage in conduct that facilitates or allows other people to use too, you're taking it to another level. And you're not only harming yourself, but you're helping other people harm themselves as well. I do think there's some mitigating factors here based on the report from Community Corrections. It looks like you stayed clean throughout this process while you've been on bond. That's not an easy thing to do. When someone has a substance use disorder, piece of paper from the court saying you can't use drugs anymore doesn't cure that. And so I can accept that you've expended a lot of effort to remain sober during this period of time. And so that, I think, is a factor that works in your favor. And it appears that you've been gainfully employed, otherwise complying with bond. So those are all positives. So, balancing those things, and with this charge of selling, you don't have a real serious prior history, but you really jumped into the deep end here. And the court's in a position on the more serious charge of delivery of your guidelines being 36 months to 60 months. And that's a significant sentence, because once you get about 36 months, you're not eligible for the boot camp program. I think, while I don't think there's any factors here that really support a downward departure, a significant downward departure, I do think that given your lack of past significant history and just the circumstances of the sales here where you were engaging in sales, but they were not significant amounts. They were relatively small amounts. The spectrum of what I see in delivery cases. I do think that boot camp is a good program. I think it might be a good program for you under your circumstances, and I don't want the sentence to include that. So for that reason, the court is going to depart downward slightly on the delivery case. The court is going, because it looks like from the report that you're otherwise eligible for a boot camp program. So in terms of the possession charge, the court is going to sentence you to 18 months in the Michigan Department of Corrections. That is 18 months to 10 years. You do have credit for 2 days served on that charge. The court is going to order restitution. Did we have a restitution amount?
$100 in each one.
Restitution of $100 to be paid to the Otsego County Clerk to be dispersed to straight area narcotics. Crime victims assessment of $130 within $68 state cost. File And that, sorry, that's in file 6992 and file 6993. The court is going to depart downward from the 36-month minimum to 30 months to 20 years. On that file, they're spread for 3 days served. Restitution of $100. Crime victims assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee is $60 and $68 state cost. You have the ability, also the court, I'll state for the record that I don't have an objection to you're otherwise eligible to your participation in the boot camp program through Department of Corrections. Mr. Dick, has Mr. Garner received his appellate?
He has, Your Honor, and he has additional days.
All right, thank you. Mr. Garner, you are into the custody of the state at this time.
Chuck, you said no objection to the boot camp program in MDOC. Thank you.
People versus Michael Gentz, file number 266998.
James Dick on behalf of Mr. Gantz, Your Honor. Please. Right.
Okay. Record should reflect Mr. Gentz is present here in the courtroom today. This is the day and time set for sentencing in this matter. And Mr. Gentz, have you had an adequate opportunity to go through the pre-sentence report and speak to your attorney about that?
I was not able to access it on my phone, but we did talk. So briefly.
You need more time to do that before we proceed today. I would be willing to give you that time.
Your Honor, yes, could we perhaps request 10 minutes?
Okay, let's take a 10-minute break and we'll come back on.
Thank you.
Thank you.
Okay, we're back on the record in People versus Gens. Mr. Gens, did you have an adequate opportunity now to go through that PSI with your attorney? Yes, sir. Okay. And Mr. Dick, I know listed on a number of different factual corrections in your brief. If you'd like to, well, I don't know, Mr. Rolla, did you review the factual corrections that were requested?
As to the factual correction, Judge, it's not that the only factual correction that needs to be done is the fact that the 10-year gap was an action. The reasons I couldn't agree.
Well, I'm not talking about that part. I'm talking about just the body of the PSI.
And again, as to the as to the changes, people don't have any real issues with it, Judge. It's actually goes to the legal side of it and the issue.
Sure, okay. Ms. Davis, do you have any issue with just reviewing the corrections to the body of the report that Mr. Dick has requested in his written response and making those changes based on that? Okay. Mr. Dick, it doesn't sound like the prosecutor has an objection to those changes, so do you have any problem with Ms. Davis just making the corrections based on your written?
No, you
That way then we don't have to go through them all individually here on the record.
Yes, and I also, if I may briefly, as it pertains to the sentencing guidelines, objection and was filed in response to the prosecutions. However, the prosecution has since corrected my alleged deficiency, and I do not have a legal argument to make against the evidence that Mr. Rollins supplied.
Okay, and I reviewed it too. I think the corrections that were raised by the people are proper objections, so the court will adopt those as well. And so the court will modify the scoring as alleged by the prosecution, which gives a change in the guideline range from 0 to 17, 2 to 17. Do you agree with that, Mr. Rolla?
Correct, Your Honor, from a C3 to a D3.
And would you agree with that as a result of those changes?
I would, Your Honor.
Okay. All right, thank you. Aside from that, Mr. Dick, is there anything else that you need to challenge with regard to the PSI itself?
No, Your Honor.
Mr. Rolla, do you have any further challenges or changes to the PSI?
No, Judge, thank you.
And anything on behalf of the people for allocation today?
Judge, these are felonies of an individual who obviously had issues with substance abuse and fell off the wagon. He did have almost 10 years of sobriety. Unfortunately, almost doesn't cut it. It was 9 years and some months. In any case, it's a circumstance where, as indicated in my brief, what was originally perceived as being a 10-year gap, which the defendant was originally trying to take credit for, actually doesn't apply for the reasons as indicated in the case law that I cited. By the way, I did cite the additional cases on the situation where even misdemeanors or traffic offenses, it doesn't have to be a felony to be scored to be counted under the 10-year gap. It doesn't require to be a felony conviction. It needs to show that the defendant did not commit any other type of offenses during that time period. And I think Wright is one of the cases that are cited. So it's a circumstance where, although the defendant may have proposed to getting things corrected, for the reasons as indicated in my brief, the sentencing guidelines are now 2 to 17 instead of 0 to 17, and probation for civil probation for 34 felonies in the position of prosecution. Believe it would be inappropriate that some jail sentence should be imposed where the offense is charged and not convicted. Thank you.
Thank you, Mr. Dick.
Your Honor, so Mr. Gens, he has completely refrained from any alcohol consumption since instance. He does acknowledge that aside from alcohol consumption, this incident happened. As Mr. Rallo pointed out, he had a significant amount of time where he was maintained sobriety, and he had kept himself out of trouble. Your Honor, Mr. Getz, he acknowledges he made the wrong choice as far as it pertains to consuming alcohol to deal with ongoing problems versus calling his counselor. Calling his counselor would have been the right choice, but unfortunately, at the time that this happened, that wasn't made. Your Honor, this initial incident was responded to because Mr. Gens himself was had been consuming alcohol. He was upset that it sounds like he was upset with himself for getting into an argument with his. There was no domestic violence or anything alleged there. However, Mr. Gens ultimately said that he really needed somebody to talk to. The PSI reflects that he had reached out to them because he was trying to call. Oh, my apologies. I have a. Let me retract that part as it regards the PSI. I have a Catholic Human Services Substance Abuse Assessment Report and a psychological evaluation that Mr. Gens sought out himself. He's upset about the situation. He's upset that he found himself under these circumstances. He's upset with himself that he consumed alcohol. During this particular situation, Mr. Gens blacked out. When he drinks, he generally wants to speak to someone about what's happening. He confided in the assessor for Catholic Human Services Substance Abuse Assessment, Miss Amy Haggerty Murphy, and said that he had reached out to the sheriff's deputy to speak to his friend. Understanding that he has on occasion when he'd been drinking called them to speak with them, to just kind of, for lack of better ways to put this, to get his mind right, to keep himself in the right state of mind. Your Honor, Mr. Gens, his real recollection of this incident, it's not what was reflected by the police report of the videos. He blacked out from drinking. This is not the person that he is outside of this one incident. He did initially agree, once the officers were there for a while, agree that he would go with them for a mental health evaluation to the hospital. However, that consensual transport was ultimately rejected. Mr. Gens changed his mind on the video, and he did. He told the officers to get off his property ultimately, and the officers responded that no, we're taking you to get checked out. There was Mr. Gens replying to them no, and he was ultimately tackled to the ground, cuffed, and it appeared he did not really understand the circumstances that had evolved during this situation. He did many things here to address his substance use issue specific to this incident. Your Honor, he went for a psychological evaluation with Old Town Psychological Services, just to get it done himself because he wanted to know if there was something more underlying the reason that he made the choice he did, the reason that things played out the way they did. He felt that he needed to do something to address what happened. wasn't sitting around being proactive, or sorry, being kind of just waiting for everything to happen with the legal system, the legal processes. He was proactively seeking a means to change himself, to avoid this going forward. The psychological evaluation was conducted by Catherine Masters, and that was on March 10th, 2026. And in that, it did reflect that Mr. Getz attends AA meetings every day. He was at that time currently going through intensive outpatient counseling with Bear River, which he did successfully complete. He was going 3 times a week, and he is presently in his individual counseling. Prior to that big gap in alcohol consumption, where he maintained his sobriety, he had been dealing with some fallout from marital issues. Alcohol was the way to deal with it back then. He put himself into Sunrise, a rehab center in Okina. Following that, he reflected this period of sobriety. This means of doing what he is doing now is the way to maintain that sobriety and continue to maintain that sobriety in the future. He does intend to continue to attend AA meetings. He goes at present with his job hours and whatnot. He is attending at least once a week. He's seen Melanie Hunt regularly and has been since 2019. He attempted to obtain a second counselor, but there were some issues with his health insurance, and they wouldn't cover. That being said, Your Honor, if the court would like to review the psychological evaluation or the substance abuse assessment, I do have a copy available for it. But the gist of that is Mr. Gantz reports that he is an alcoholic. Both of his parents used substances when he was growing up. He does deal with depression, first diagnosed when he was 16 years old, and anxiety at the age of 38. He was taking both Prozac and Ativan to deal with these issues. Since he has quit drinking, he now does not take any of that medication. He finds himself in a new and better place. He's a father of 4, works hard every day, and he's a father of 5. He works hard to support 4 of them on a regular basis here. And Your Honor, he does have things in place to make sure that he doesn't encounter these circumstances ever again. That being said, I'm asking the court to consider a delay sentence, allow him to continue his work, his treatment, his and just to show the court that he will continue on this path of sobriety and path of doing what he's supposed to under the law and any probationary terms that the court does require. That being said, Your Honor, if the court did find at the end of that delay that he required some sort of a jail sentence, the court would have the discretion to do so. If the court requires any sort of upfront jail sentence here, then we would ask that the court considers some sort of work release. As noted in the PSI, there was no objection to work camp release if he was eligible. That being said, Your Honor, we just ask that the court considers the delay of the sentence as well.
Thank you. Mr. Gantz, anything you wanted to say today?
Yes, sir. Say that I wouldn't be here if I hadn't made a bad decision on how to deal with what I was going through at the time. It was a bad choice. I thought by doing, I can only think that by seeing the video at the time, I was making the right call to who I should have called. I have taken all the steps to make sure that this is something that is looked at and talked about, and it is a matter that is being dealt with my counselor and myself. I will continue to go to AA and anything else that the court requests for me to do in this. And again, I apologize for my actions.
All right, Mr. Gens, I did read through the pre-sentence report, so I'm familiar with the circumstances that bring you here before the court today and what occurred during this incident. I didn't get the video, so I haven't seen the video, but I'm going on the description of it from the police report that's reflected here in the pre-sentence report. There's also a lot of information in there about your background and your circumstances. I took a very close look at that just as part of this issue with regard to the scoring guidelines. So I'm familiar with your past history, criminal history, as well as your circumstances generally. And I take all of those things into account along with what the lawyers had to say here today, along with yourself. I think there's, certainly some competing factors. There's some mitigating factors here that I think help your case. Number one, the report from Community Corrections does indicate that you fully complied while you were on bond. That's certainly positive. The fact that you're seeking counseling and treatment and getting assessments to try to identify the root of the problem, I think is also positive. There are also some negatives, primarily your behavior during this incident, completely outside the scope of anything remotely considered acceptable in terms of behavior directed at law enforcement officers who were simply really trying to address your needs at the time. But your behavior during this incident, well beyond the pale. Anything that law enforcement should have to deal with.
Can I say something? The video or the police report does not reflect in the video at the time when I was telling the officers that they were good men and that they deserve to be recognized for the services that they provide. And that's literally in the video. I was not rude to the officers. I made, I think, a couple stupid jokes, but I was not in any way, shape, or form in threat to them. It was mainly, I was dealing with something. I had a panic attack during the situation that was stated in the police report.
You telling them that they were good men, was that before or after all this other stuff?
It was, that all happened before I was arrested. I was absolutely compliant with them, and I was sitting on my tailgate for the majority of the time.
Okay, so all the stuff that you did happened after you were.
I was told all of that was some stuff that I said in the car on wherever they were taking me at that. I don't remember.
Well, there's a lot of other stuff you did in the car.
Absolutely, there is. And
That's what I'm talking about.
that was a stupid choice.
Yeah, that's what I'm talking about.
Yes, sir.
I don't know. I'm not sure if you're helping yourself.
I'm sorry.
Rarely does, well,
I was wrong.
regardless. Your behavior towards the officers, what you did in the police car, spitting, kicking, damaging the police car, threats to kill law enforcement, lunging towards the deputies, trying to kick them in the chest. They had to put a spit mask on you. I mean, literally, they had to sedate you to get you to calm down. So none of that is acceptable at all. And I don't care what you said to them before that. That's what you did after. And they had to deal with you being completely out of control that night. So that's certainly a negative. And then when I view that in context of your history, you've got a history of this kind of stuff. And so, you've been on probation 7 prior times, had 5 prior jail sentences. So it's not like this is a one-time thing and maybe you were sober for a while and you didn't get in trouble, but here we are again, and you're repeating the same behavior over that you repeated in the past. So I can't look at this as you just had one bad night, you drank too much, you blacked out, and got out of control. This is something that's been a pattern with you throughout your adult life. And regardless of breaks in that, I have to recognize that prior efforts at stopping this haven't been successful. So I have to balance those two things, the good parts and the bad parts. And when looking at what I think an appropriate sentence is for your conduct in this case, number one, I don't think further probation is appropriate. I don't think it's beneficial to the community or to you. Again, you've been on probation 7 prior times, so I don't think the 8th time is the one that's going to finally do it. I think a jail sentence to account for your conduct in this case, to punish your conduct, deter it, hopefully in the future, is where we're at this point. The guidelines, as we said, are 2 to 17, so the court would be within the guidelines to impose a prison sentence. I don't think that's appropriate given, again, mitigating factors here. Although based on your past history, I think a jail sentence is certainly appropriate. And I think further incidents like this, to the extent that you don't follow through with treatment and getting help, I think you're going to find yourself in a position where prison is going to be the next step, the next time you're before me or any other court. So the court is not going to place you on probation. The court is going to impose a straight jail sentence of 9 months. I find that that's, again, a reasonable sentence. It accounts for your past history and attempts at correction and your actions towards the officers in this case. It's in the middle of the guidelines, and so I think it balances the positives with the negatives. So the court will impose 9 months in the Otsego County Jail. You do have credit for 3 days served. Crime victims assessment of $130, court costs of $325, attorney fees of $350, DNA testing fee of $60 and $136 state cost. You do have the ability to seek an appeal of the sentence and provide you with an acknowledgement of those appellate rights. Those sentences as to both charges. Mr. Dick, can you just let me know once Mr. Gens has acknowledged receipt of his appellate rights?
Yes, Your Honor.
Thank you, Mr. Chair, again, into the custody of the county. That concludes our morning docket. Court will be in recess.